11.1 Introduction. Dr. Mahima was an academic counselor at an IGNOU study center and was interacting with the learners of BPCE 142 course. Let us look at their conversation. Dr. Mahima: so learners, in the block 1, 2 and 3 of BPCE 142, you learnt various aspects of forensic psychology. Learners: yes ma'am. Dr. Mahima: so can you highlight a few points that you learnt? Sonia: learner, forensic psychology can be described as an application of principles of psychology to legal system. Salim: learner, also ma'am, forensic psychology has various subspecialities including investigative psychology, criminal psychology, legal psychology, and correctional psychology. Maria: learner, also ma'am, we discussed about these specialities as well in detail in some of the units under block 2 and 3. Dr. Mahima: that's right. Navjio: learner, we also learnt about the roles of a forensic psychologist including the experimental role, the actuarial role, and the advisory role. Samina: learner, and the functions, from aiding the police in their investigations, advising in the selection of police officers, providing expert evidence to the court, working with offenders, conducting assessments and interventions, carrying out research or imparting their knowledge to future. The functions of a forensic psychologist are varied and challenging. Dr. Mahima: yes indeed. John: learner ma'am, we also learned about assessment in forensic psychology, especially personality testing. Dr. Mahima: that's right. And I am happy that you have revised well, and I am also happy that now you are already aware about the basics of forensic psychology, which will help you in understanding its application. Ravi: learner, so ma'am, what are the areas where forensic psychology can be applied? Dr. Mahima: well, these areas range from civil and criminal proceedings, child-related issues, juvenile delinquency, homicide, serial killing to public policy. And I would like you to read about these for the next session. As you can see from the discussion between Dr. Mahima and the learner, in Block 4 of this course, we will focus on various areas of application of forensic psychology. And in the present unit, the focus will be on application of forensic psychology to civil and criminal proceedings. 11.2 Forensic Psychology and Law. Forensic psychology, as mentioned in earlier units, is the application of psychology, its principles, philosophy and techniques to the legal/justice system. While law deals exclusively with legal issues, crime-related problems, the perpetrators of crime, their victims and the whole lot of legal issues. Further, forensic psychology deals with understanding human behaviors at different levels, their emotional pattern, their intelligence level and so on, and law deals with mainly all problems that are related to criminal and civil proceedings. Law looks at the crime with a totally different goal, that is to render justice to the victims affected by crime, wherein the victims have lost their livelihood in many ways, sustained serious injuries to their bodies, or even lost their limbs and organs, and in quite a few cases they have even lost their lives. To render justice to the victims or even to the perpetrators, the law looks to the forensic psychologists for varied types of help, including that of assessment and evaluation of the mental status of the victim/accused. Thus, forensic psychology and law have a very close relationship in the sense that psychology is applied to law and legal issues in a big way. Forensic psychologists who are asked to assess and evaluate the mental status of a victim or an accused, do so and present their expert testimony based on their scientific finding resulting from their assessment and evaluation. Other evaluations and assessments include the individual's competency to stand trial, whether a crime has been committed due to mental disorder, etc. They also, through criminal profiling, be able to indicate the risks of the same criminal committing another crime. Using psychological tests and interview techniques, the forensic psychologists evaluate and assess the capability and emotional and psychological balance as well as economic stability of people who desire to take custody of a child after divorce or other kinds of separation. They even assess the home atmosphere, the character of the persons who want to take custody and present their reports in detail to the court. Since forensic psychologists have to deal with both criminal and civil cases, they need to be thorough with all aspects of the law. Forensic psychologists deal with the emotions, cognition and behaviors of people who come in conflict with law or in one way or the other involved in the legal system. Also, forensic psychologists work within the legal system and may take the cases referred to them, which may be the accused or the victim. It is well known that the law protects the public and also every individual from all sorts of crime, injury, etc. When an individual is assaulted, he/she appeals to the law for justice and expects punishment for the assaulter who had injured him/her. Further, in any conflict that arises in the society, the law defines what is the correct behavior and prescribes punishment for the wrong behaviors. Forensic psychology helps in rendering fair judgment by investigating not only the physical aspects but also the mental and psychological aspects of the person concerned. Their analysis of all the cases is inductive and probabilistic in nature. As for the role of forensic psychologists in the courtroom, they are called by the police, lawyers, or even judges to interview and assess criminals. The information obtained by them from these interviews etc. are used by the court of law. For instance, in the medico-legal ward, on the mandate received from the court, a forensic psychologist may work in the area of rehabilitating the criminal or the victim or both. In India, under Section 45 of the Indian Evidence Act 1872, the court can take the help of experts such as a forensic psychologist or a document expert etc. Thus the forensic psychologist presents facts to the courts so as to help the court to deliver justice in a fair and just manner. Also, the role of forensic psychologist would help in deciding mens rea of the person concerned, that is, they would be able to assess if the accused state of mind was balanced or not. Where the person claims that he/she committed the crime because he/she was under the influence of some substance or was unaware that he/she has indulged in a crime. Such a claim gives the defense an opportunity to reduce the severity of punishment or delay the final verdict of the judge. In such cases, forensic psychologist, the expert, is required to provide an opinion as how true the accused's statement is, so that the judge can deliver a fair judgment. Section 45 of the Indian Evidence Act allows the forensic psychologist to give his or her expert opinion in solving the criminal investigations. 11.2.1 Forensic psychologist as an expert witness. As discussed until now, there is considerable scope for forensic psychologists to work in collaboration and in unison with the law. They have multiple roles as seen in the Proceedings section, that in managing many legal problems and issues, especially from the point of view of analysis and understanding of human behavior, irrespective of the behavior being in conflict with law or one in line with the law. Forensic psychology is a specialization which focuses on psychological assessments of criminals, forensic offender profiling, and research into the volatile internal prison systems and related issues. They present their professional opinion on how they believe the court should proceed in sentencing the person in terms of the mental health problem and related risk factors. For example, they could inform the court about the dangers of self-harm or committing suicide, or becoming violent at future stage, by the accused or the victim, and may even suggest routine psychological treatment for the person. As forensic psychologists offer a thorough comprehension of the criminal case, and also because of the expertise that he/she has in regard to criminal behavior from psychological perspective, the forensic psychologist is asked to present his opinion regarding a criminal case to the court as an expert witness. He/she can be asked to present his/her expert opinion in either of the defense or prosecution case as he/she is equipped with relevant skills to assist in criminal defense case. Furthermore, when forensic psychologists is asked to present their opinion about a case referred to them, they do a series of psychological/psychometric assessments, the results of which will indicate many of the undiagnosed behavioral issues. Since the tests used by forensic psychologists also tap the motivation for a certain behavior, they are able to clearly indicate why or what motivated the accused indulge in criminality. Thus, they submit a very comprehensive report, give explanations and interpretations of the obtained result, giving their own conclusions, how and why they arrived at the same, etc. Such information and comprehensive report help a great deal in a fair trial and prevents any miscarriage of justice. Thus, forensic psychology has many roles regard with the law. Even though there are many differences between the research methods and techniques used by forensic psychologists and the legal experts, the fact remains that both have the same goal of wanting a more accurate and efficient legal system that fits human behavior. In other words, both their goal is to make sure that fair and just judgments are pronounced which would benefit the victim assaulted by a criminal and if it had been absolutely proved beyond doubt. It also must ensure that the accused is also given a chance to be rehabilitated back into the community after he/she serves his term in incarceration as punishment awarded to him/her by the court. 11.2.2 Forensic psychologist as the court-appointed evaluator. Forensic psychologists are also known as house psychology professionals within the courts. These experts deal with complex evaluations and also handle legal considerations. Forensic psychologists are also cross-examined in the court. Many courts in the USA and UK and other advanced countries also have built-in evaluation services and court clinics, wherein qualified professional psychologists offer efficient psychological services such as testing, evaluation, diagnosis and treatment. As pointed out elsewhere, in adult courts forensic psychologists deal with the competency of the victim and the accused to stand trial. In this the forensic psychologists not only evaluate the mental status, but explore many judicial items including processing and reasoning abilities of the person, in regard to the charge made on him/her, and his/her understanding of the acceptance of guilt versus going to trial. If found competent, the individual, that is the accused, goes on to trial, or else if found incompetent, he/she is sent back for treatment etc. until he/she is declared competent to stand trial. b. The evaluation that the criminal behavior of the accused was influenced by a mental defect or mental disorder that rendered them incapable of appreciating the unlawfulness or the wrongness of their criminal behavior and action. Such an evaluation may lead to insanity defense. Another evaluation done is the psychiatric crisis evaluation. This is requested by the court of the forensic psychologist, whenever a defendant or the accused presents acute mental health problems within the court. A risk assessment is performed by the court clinician or the forensic psychologist, and if necessary the person concerned may also be hospitalized. Based on the evaluation carried out by the forensic psychologists, they could also be invited as experts to testify in the court. Such appearances of the forensic psychologist is known as expert witness, and these persons have the more information and knowledge about the situation as they are experts in certain topics and also have specialized knowledge of the same. They are experts in areas like mental health related issues, social, experimental, cognitive and developmental problems. At the same time, the judge decides whether or not the statement of the expert is accepted, 11.2.3 Forensic psychologist as a researcher. Forensic psychologists engage in teaching in universities covering topics such as psychology of criminal behavior, investigation, assessment and treatment of offenders, and impart to students how to conduct criminal psychological research. Forensic psychologists conduct research in the areas such as criminal profiling, crime trends, effective mental health treatment of offenders, effective treatment for substance abusers, techniques for jury selection, impact of divorce, visitation, custody, etc. Thus, forensic psychologists may serve as both clinicians and researchers. In addition, they also focus on research issues related to law and legal system. They also focus on the effectiveness of risk assessment strategies, importance of questioning and evaluating eyewitnesses, their memory and recall abilities. In addition, forensic psychologists evaluate the offender and victim treatment programs, effective stress management interventions for personnel in law enforcement as well as in the legal system. A few also take to conducting research on devising psychological tests that are important for the legal system, criminality, custody evaluations, testing of children and parents, causes of criminality and delinquency, violent behavior, to social thinking, and so on. Furthermore, research in psychology impacts law in many ways, for instance, memory, cognition and social influence effects of these on the individual, and his/her statements regarding a crime or whatever he/she witnessed etc. can be totally misrepresented due to cognitive distortion or memory confusion, and may end up in wrong judgment. Many researches by forensic psychologists on the witness testimony have clearly indicated that memory of a person regarding any event can be influenced by many factors including suggestions. Forensic psychologists also conduct applied research which have a direct bearing on the impact of various factors on the legal issues. The applied research is used for specific problems like psychology and the law, as for instance, the psychologists who are trained in interviewing skills etc. can easily indicate whether a suspect is lying on the basis of their observation and interpretation of the accused's non-verbal behavior. Thus, many such researches are available which relate to the impact of many psychological factors on the individual's behaviors that come into conflict with the law. In the USA, forensic psychologists also evaluate the impact of witness testimony and experts' testimony on the jurors. They also try to find out through research to what extent the jurors' decision is influenced by the materials they read up during pre-trial stage. In the USA, there are drug courts which are also evaluated by forensic psychologists to ascertain if these courts in any way deter recidivism. Many researches including those on eyewitness memory mentioned above, the eyewitness testimony, repressed memory which needs to be considered case by case than applying it to every case, the juror's bias due to studying pre-trial materials and media publicity of the case, the wrong confessions obtained by the interrogators due to their coercive and other methods leading to wrong conviction, and finally the coming to a decision by the jury being highly colored by many events occurring to which they inadvertently or otherwise exposed are indicative of some of the very researches by forensic psychologists that very often save the courts and the judges from convicting the wrong person or an innocent person. It is therefore important for forensic psychologists to delve deep into these areas, conduct research which could throw light on the differences in the legal expectations of the jurors and the latter's actual capabilities to be neutral, factual, truthful, unemotional, fair and just. When forensic psychologists deal with the persons coming in conflict with the law, important questions that arises is how can jurors make their legal decisions in case of medical incapacitation? Can forensic psychologists or the lawyers or the medical doctors assess the integrity of a person, an adult with cognitive disabilities? This requires considerable research attention. Another area is the criminal profiling and predicting a person's, criminal's, behavior at a certain point of time based on the profile created for him. Forensic psychologists also play a role in developing the psychological profiles of the offenders, teach and train the law enforcement officials, and provides counseling services to police officers also. In addition, they conduct research on the development of abnormality and psychopathic trends in delinquents, provides counseling to school personnel to identify those youngsters who may be dangerous to the society and assess risk among the mentally ill persons. As mentioned earlier, they also devise psychological tests. In regard to the victims, they do counseling to help them tide over their trauma, deals effectively with PTSD, and educate the service providers on the impact of multiculturalism in mental health of the persons. To conclude this section, many services and assistance are provided by the forensic psychologists in the court of law, in both civil and criminal cases. Their contribution to child welfare, child custody, etc. are of great value to the judges who need to take the correct decisions and deliver fair and just judgment. Box 11.1 Civil and Criminal Proceedings. Making the right choices and acting on those individual choices are considered to be most fundamental rights of any human being. Choices or actions that are not restricted or prohibited by criminal law are considered to be private to an individual. Civil law is concerned with civil or private rights and legal remedies rather than the public concern of crime. They are sometimes referred to as private law because may regulate private relationships between individuals in our society and deal with the rights and obligations of people and what is needed to protect them. In civil law, a private party such as an individual or a corporation files the lawsuit and becomes the petitioner. Civil matters include contract law, family law, tort law, property, and labor law, etc., and civil disputes usually involve some harm, loss or injury to one party of their property. If a civil case is successful, the defendant is held responsible for the wrongful action and said to be liable or not liable for damages. A defendant in civil litigation is never incarcerated, unless fails to compensate, and never executed. So-called punitive damages are never awarded in a civil case unless the defendant conduct is found to be egregious and had either malicious intent, that is, desire to harm others, gross negligence, that is, conscious indifference, or a willful disregard for the rights of others. This section would include domestic law related to adults and children, assessment of children and adolescents, evaluation of civil competency, personal injury, work-related compensation issues, disability, and trauma caused by sexual harassment and rape. The broad purpose of criminal law is to prevent certain undesirable conduct and, thereby, to protect various interests of the society. Criminal law is framed to impose punishment for the undesirable conduct with an intention to rehabilitate offenders to protect the society. In a criminal case, the state takes upon itself the responsibility to file the litigation, investigate and collect evidence with the help of police, to fight the case in court, through a public prosecutor, and enforce the punishment. The procedure by which a law trial is conducted is also quite different from the processes involved in a civil trial. An important difference is that the standard of proof required in criminal cases is much higher than the civil cases. Since criminal law is centrally linked with issues of punishment, allegations and facts must be proven beyond reasonable doubt so that innocent people are not punished. In criminal law, a guilty defendant is punished by either incarceration in a jail or prison, fine paid to the government, or, in exceptional cases, execution of the defendant, the death penalty. Crime are divided into two broad classes: felonies, that have a maximum possible sentence of more than 1 year incarceration, and misdemeanors, that have a maximum possible sentence of less than a year's incarceration. Punishment in criminal cases is awarded with a notion that the threat of punishment will deter criminal conduct, and assumptions that humans are rational beings. However, in practice, it has been shown that individuals get involved in criminal activities are either impulsive, that is, not rational, or believe that they will not be caught by the police. 11.3 Forensic Psychology in Civil and Criminal Law. Forensic psychologists have an important role to carry out in the civil courts. For instance, they provide psychological evaluations for people who seek financial compensation for the damages they have sustained due to accidents, etc., or someone's attack on them or fault. The forensic psychologist investigates and examines how genuine is the claim or demand for compensation. In addition, they also conduct psychological tests to ascertain the mental health of the person and his or her emotional distress. Forensic psychologists give expert testimony in the civil courts also related to legal matters in a civil law court. They also work in prisons, work with juveniles in juvenile homes and children's homes, youth counseling and research in various areas that provide insight into the many white-collar crimes. White-collar crimes, which are also dealt with in civil courts, are often committed persons who do not really bother about the harm they cause to the people whom they are duping, and these people never get close to the victims. Most of these crimes refer to manipulating, accounting and finance systems. The motivations, the character and the entitlement that they exhibit vary a great deal amongst these fraudsters. These people are also opportunistic and rationalize their fraudulent behaviors, and a few are quite guilt-ridden. These persons are driven by narcissistic and antisocial personality disorders. Some of them may not even get the financial benefit. The type of offenses in this category include property crime, economic crime, and corporate crimes. The white-collar criminals are often affluent, can engage an expensive lawyer and get away with their problems. They generally live beyond their means and invariably struggle with financial difficulties. Every organization does have this kind of problem and fraudsters of this type. However, it is important to identify the warning signs of fraudulence. Forensic psychologists, especially certified in fraud examination, do put across some of the typical characteristics of these persons and suggest remedies too. Thus, in such cases, once they identify the person who has indulged in fraud, they try to compensate the victim through the civil court, where they make statements and contribute to the and indicate also the emotional stress the victim has undergone in addition to the heavy financial loss. Forensic psychologists are scientist practitioners who apply psychological theory techniques and skills to not only understand the criminal justice system but also to conduct research in the relevant areas. Forensic psychology focuses the following in civil law-related cases: work in prisons, at-risk youth counseling and academic research. It assesses wide array of people including victims of crime, expert witnesses, eyewitnesses and their testimony, lawyers and laws enforcement. Whenever a victim complains that because of the actions of the fraudster, their emotional stability has been disturbed and they are highly distressed and they want monetary compensation, the forensic psychologist evaluate their claims and present their opinions to the court, which includes both the damages suffered by the victim as well as the cause of the damage. In other words, the forensic psychologist finds out the emotional condition before as well as after the fraud perpetrated by the fraudster. Forensic psychologists working on cases related to civil law investigate by reconstructing the entire scene. They also give expert testimony, do consultation in regard to the cases referred to him/her or those who approach him. They also prepare the witnesses for the trial and last of all take up the task of reviewing and analyzing the records related to the case concerned. Forensic psychologists present their professional opinion on the basis of a. the evidences they have obtained in regard to the case through their detailed investigations, b. interviewing the accused as well as the victim and obtain data on their personal life history in a developmental format, their educational level, employment history, family and marital history and details thereof, medical history covering both physical and psychological problems that the individual had suffered earlier, and also whether he has any physical or psychological ailments, and if they have had any legal problems and legal histories. C. Psychological testing of both accused and the victim, using tests such as the MMPI, TAT or other personality assessment inventory and the Rorschach test. While MMPI, Minnesota Multiphasic Personality Inventory, covers a large number of personality traits and dimensions of the individuals, the TAT, Thematic Perception Test, covers the many conflicts the individual faces with people outside of himself and also within himself/herself, and lastly the Rorschach test covers the many unconscious factors that impact also the conscious aspects of the individual's conflicts and personality characteristics and brings out some of the maladies such as depression, anxiety and fears that the person is experiencing. Some of the major civil legal issues dealt with by the forensic psychologist are emotional damage, involuntary treatment, guardianship, harassment and discrimination, civil competency, professional malpractices, product liability and psychological autopsy. As we have mentioned earlier, forensic psychology is the interface between psychology and law. It is mired with complexities and face many vulnerabilities. These professionals serve as expert witnesses in court during their professional practice. Forensic psychologists assess the level of criminal and legal responsibility of defendants in cases of fraud, embezzlement, murder, physical aggression, and other crimes and court proceedings. In order to evaluate inmates for release, the forensic psychologists study the risk factors for repeat criminal behavior, study and analyze through research the neurobiological aspects of psychopathic personalities. This helps to predict possible threats to society at large. Forensic psychologists also assess litigants in custody disputes and insurance claims. In family courts they offer psychotherapy services, perform child custody evaluations, investigate reports of child abuse, and conduct visitation risk assessments. Forensic psychologists in civil courts are asked to assess mental competency of the accused as well as the victim to find out how far they are competent to stand trial in the civil courts. They also serve as alternate expert witness, as and when required. However, in a number of cases where they diagnose any mental health problems and the individual requires psychotherapy, they do undertake these therapeutic interventions to both accused and the victim. They also work with children who have witnessed a crime, who are traumatized and who are to appear as child witness in the court. Also, forensic psychologists evaluate and assess the juvenile as well as adult offenders for sentencing. All these assessments that they make are also used by them in diagnosing a case and prescribing psychological treatment. This diagnosis in turn also answers the legal questions and substantiates the main aim of the evaluation undertaken. 11.4 Forensic Psychology and Assessment of Civil and Criminal Competency. The right to select is a fundamental societal value, but in certain situations, an individual's ability to make personal choices may be questioned. In such situations, individual autonomy must be weighed against another societal interest, that of protecting the individual. Competency as a legal term has been defined by Black's Law Dictionary as the mental ability to understand problems and to make decisions. The precise meaning of competency assumes different forms depending upon the context for which it is addressed. The legal requirement of competence to stand trial is an extension of the general rule that no one should be tried for a crime in his/her absence. If a defendant must be physically present to defend against criminal charges, that defendant must also be present mentally. An individual should not be subjected to the process of legal system if he/she is unable to understand the nature and purpose of those proceedings. Disorders that interfere with the psychological participation of a defendant at trial render that defendant incompetent to stand trial and require the postponement of the proceeding till effective participation can be assured. The issue of an accused/defendant's competency is present throughout the legal proceeding against him/her. The question of competency to stand trial involves three separate questions. Does the defendant have a genuine mental disorder sufficiently severe to justify a finding of incompetence? Diagnosis. 2. Is the defendant unable to understand rationally and factually the legal proceedings and to assist counsel in defense? Incapacity. And 3. Is this incapacity caused by the mental disorder? Causation. Competency may be significantly affected by pre-existing cognitive limitations or an underlying psychiatric disorder. However, the presence of a mental illness alone is insufficient to indicate a lack of capacity. A genuine mental disorder causes a defendant to be incapacitated, and a genuine mental disorder does not cause a defendant to be incapacitated. Some special legal and/or clinical problems may be posed in following circumstances, i.e. in case of defendants who have a genuine diagnosis that causes an insufficient incapacity to stand trial, in case of defendants who have a genuine mental disorder but whose impaired capacity to stand trial is due to fabrication or exaggeration, and in case of defendants who have a genuine mental disorder, who are incapable of standing trial, but whose mental disorder is not severe enough to justify a finding of incompetence. A context-specific functional impairment should also be present. 11.4.1 Assessment and evaluation of competency to stand trial. Competency issue arises in both civil and criminal arenas, and in general court conducts such evaluations in an effort to safeguard the individuals. Assessment and evaluation of competence is based on 4 elements, specifically with regard to having the requisite mental skills for the acquisition, comprehension, and processing of relevant information in order to make a decision. The individual must understand the basic facts of a given situation, implication of the situation and its relation to himself/herself. The process of referring a person for an evaluation to assess competency can occur any time prior to the adjudication. The question of the defendant's competence to proceed in a court trial can be raised by the arresting officer, jail staff, prosecution or defense counsel, or even by a family member. Whenever the sanity of the accused is likely to be a significant factor at the time of trial, the access to psychiatric evaluation is a must. In actual practice, all the participants in the criminal process are usually able to identify readily the majority of incompetent defendants. Actively psychotic, demented, and severely mentally retarded persons are usually recognized by arresting officers, jail personnel, or defense attorneys and transferred to treatment facilities prior to any court appearances. However, defendants charged with particularly notorious crimes and defendants who decompensate while awaiting trial often require professional evaluation before criminal proceedings are postponed. At times the defense attorneys raise issue of competence to stand trial for their apparently competent clients in order to secure a court-ordered professional evaluation of the defendant which would be otherwise unavailable. These evaluations may produce evidence relevant to an insanity plea, to the question of diminished capacity, or to mitigating factors which may be considered at the time of sentence. The competency to stand trial is a legal standard and not a psychological or psychiatric or medical concept. The psychologists/psychiatrists as mental health consultants are, therefore, Faced with the challenge of explaining the court about a defendant's mental symptoms that affect his/her capacity to understand, participate, and make decisions. The role of the forensic psychologist/psychiatrist as court consultants is, therefore, to explain a defendant's capacities in relation to the relevant legal concepts. The mental health consultant will consider three primary factors which are relevant to the defendant's competency to stand trial. The examination of general cognitive capacities of the defendant will reveal his/her basic level of knowledge and about court-related matters. If a defendant displays the symptoms which will interfere with his/her general capacities, there is little reason to go further. The examination of decisional capacity of the defendant will indicate whether he/she can apply these capacities to the specific decisions he/she is facing in the legal case. It is important to recognize that competency to stand trial is based upon a capacity to make reasonable decisions, not whether the decisions were reasonable. People are free to make unreasonable decisions, although they may be having the capacity to do otherwise. The examination of the defendant's capacities relevant to his/her specific case will indicate how the defendant's mental condition or situation interacts with the unique features of the case. Various forensic assessment instruments have been developed by different researchers in the field. These are MacArthur Structured Assessment of the Competencies of the Criminal Defendants, Georgia Court Competency Test, Georgia Court Competency Test Mississippi version revised, the Competency Assessment Instrument, the Interdisciplinary Fitness Interview, and Competency Screening Test. There are numerous assessment tools, but there is no standard tool to evaluate capacity, and evaluations include minimum clinical interview and review of available records. Forensic evaluator should utilize validated and current instruments and methods within a broadly designed assessment approach, which includes assessment of present psychopathology and response styles. 11.5 Criminal Responsibility and Insanity Defense. Under the law, except for strict liability offenses, to declare a person guilty of criminal act, that person should not only have deliberately committed the act, actus reus, but also must have understood the consequences of his act in totality and had the intent to commit the act, mens rea. Thus, in this context, it is important to discuss about two terms, criminal responsibility and insanity defense. 11.5.1 Criminal responsibility. Criminal responsibility is the fact of being responsible for a crime that the person has committed. Criminal responsibility applies not only to those who perform criminal acts but also to those who aid and abet a perpetrator by encouraging or in any way knowingly helping in the commission of such an act. The precise definition of criminal responsibility varies from place to place, but, in general, to be responsible for a criminal act implies that the perpetrator must understand what they are doing and that it is wrong. An individual may not be considered responsible for having committed a crime if the person is a child who does not understand what he/she is doing. Let us say two children of age 3 years or so are playing near a bathtub with water and one child pushes the other child into the water playfully and the other child dies in the process. In such a case, the child cannot be held responsible for the killing of the other child because both of them were playing and in play without any understanding of the implications. The first child pushed the second and the second child died. Here there was no intention to kill but just play activity. The age factor thus plays an important role in criminal responsibility. Another aspect in which one cannot consider a person responsible for committing a crime is mental disorder. Let us say a person suffering from paranoid disorder, highly suspicious when suspicion is not at all warranted, feels threatened by persecutors and runs for life from those persons. He/she is so scared of the persecutors and imagines a person in his office being at the root of it. he/she is convinced that by killing that person he/she could be saved from being persecuted. Such a person who kills is doing so because of a delusion, false belief, that he/she is getting persecuted by villains under the orders of a person in his office. This is a mental illness, and under this condition a person can go and kill another but is not aware of the various consequences. Hence such a person cannot be held responsible for killing. In yet another case a person may be hearing voices, auditory hallucinations, to go and kill Miss X, and he will go and kill that person and come back, least realizing the consequences of his actions. In such cases the person cannot be held responsible for committing the crime. Thus, on grounds of mental disorder the person may not be held responsible for the criminal action. A landmark case occurred in 1843, when Daniel M. Nathan shot and killed the secretary to Britain's Prime Minister Robert Peel. The medical evidence found M. Nathan to be insane. This led to the famous M. Nathan rule, where someone could evade criminal responsibility if it could be proved that they did not understand the nature and quality of the act they were committing. Equally, they were not held responsible if they did understand what they were doing, but did not know or realize that it was wrong. Persons suffering from a psychosis may be so out of touch with reality that at the time of the crime, the person may not realize what he is doing and what consequences such a criminal action will have. Disorders of impulse control may mean someone is unable to stop himself or herself from attacking someone. People whose actions and judgment are affected by prescription drugs may also not be fully responsible. Crimes with no apparent or rational motive may also be committed by those who are not fully responsible for their actions. Box 11.2 Mens rea. Criminal intent or reckless state of mind is one that the prosecution must prove that an accused had at the time of committing the offense to secure a conviction. Ordinarily, a crime is not committed if the mind of the person doing the act is innocent. There must be some blameworthy condition of mind, mens rea, before a person is made criminally liable. For instance, causing injury to an assailant in private defense is no crime. However, the moment injury is caused with intent to take revenge, the act becomes criminal. It must be kept in mind that the requisite guilty state of mind varies from crime to crime. What is an evil intent for one kind of offense may not be so for another kind. The underlying principle of the doctrine of mens rea is expressed in the Latin as maxim actus non facit reum nisi mens sit rea, meaning the act does not make one guilty unless the mind is also guilty. Those who actually perform the criminal act, for example, wielding the weapon that strikes the fatal blow, are often called principals in the first degree. Those who assist at the time of the commission of the offense, for example, holding the victim down while the principal in the first degree strikes the blow, are principals in the second degree. And those who assist before the crime takes place, for example, by lending the weapon or by providing information, are accessories before the fact. Usually, the law considers all equally responsible and liable to the same punishment. In many cases, though, the accessory before the fact is considered more culpable. For example, if he/she has instigated the offense and arranged for it to be committed by an associate, and in some cases the person who actually performs the criminal act is completely innocent of all intent, for example, a nurse who unknowingly administers to a patient, on a doctor's instructions, medicine that turns out to be poison. In the latter situation, the person who carries out the act is an innocent agent and not criminally responsible, and the person who caused the innocent agent to act is considered the principal in the first degree. The mere commission of a criminal act, or bringing about the state of affairs that the law provides against, is not enough to constitute a crime, at any rate in the case of the more serious crimes. These generally require, in addition, some element of wrongful intent or other fault. Mens rea in the Indian Penal Code 1860. The Indian Penal Code 1860 sets out the definition of offences, the general conditions of liability, the conditions of exemptions from liability and punishments for the respective offences. Lord Macaulay and his colleagues have not used the common law doctrine of mens rea in defining these crimes. However, they preferred to import it by using different terms indicating the required evil intent or mens rea as an essence of a particular offence. Guilt in respect of almost all the offences created under the IPC is fastened either on the ground of intention, or knowledge or reason to believe. Almost all the offences under the IPC are qualified by one or other words such as wrongful gain or wrongful loss, dishonestly, fraudulently, reason to believe, criminal knowledge or intention, intentional cooperation, voluntarily, malignantly, wantonly, maliciously. All these words indicate the blameworthy mental condition required at the time of commission of the offence, in order to constitute an offence. Thus, though the word mens rea as such is nowhere found in the IPC, its essence is reflected in almost all the provisions of the Indian Penal Code 1860. Every offence created under the IPC virtually imports the idea of criminal intent or mens rea in some form or other. 11.5.2 Insanity defense. Insanity is a legal term and not a term of psychology. Insanity implies that if a person suffers from mental illness, he/she cannot realize what he/she is doing, why he/she is doing and what such an act will have repercussions on the individual, etc. Such an illness renders a person incapable of thinking and be unable to understand or appreciate the nature of their behavior. Only in such cases the criminal intent is negated. Before proceeding further, it is important to know what is sanity/insanity. Sanity refers to a defendant being capable of committing a criminal action. Whether he/she can be held responsible for his/her criminal action or criminal behavior. On the other hand, insanity defense refers to the person, when committed the crime, was not of sound mind and hence not capable of understanding what he/she was doing, why and the consequences of his action. He/she thus is unable to appreciate the true nature of the crime that he/she has committed. Using this concept of insanity, the accused who stands trial and considered to be capable of standing trial may yet be found not guilty because at the time of committing the crime he/she was not of sound mind. Insanity is defined legally as a defendant lacking criminal responsibility as he/she suffers from a mental disorder or a mental defect, due to which he/she is unable to appreciate the crime he/she has committed. This mental disorder or mental defect may also render him/her incapable of appreciating the misconduct as a violation of ethical behavior according to the society. Also, this mental defect or mental disorder, the defendant may believe that committing the crime is morally justified, though he/she is quite aware that his criminal actions are illegal and is also a violation of the social and moral standards. On the other hand, sanity in legal terminology indicates that the accused in regard to a crime that he/she has committed is knowledgeable regarding the consequences of his/her act, and when assessed by forensic psychologists for competency to stand trial, etc., they do find them capable of understanding and dealing with the trial, could put across their points to their lawyers, etc. Both the court and the lawyers depend on the forensic psychologist's report on their assessment of the accused and try to understand the concepts from psychologist's point of view and professionally determine the issue based on their legal definitions. Thus, insanity and sanity are looked into from both psychologists' and the advocate's points of view. While sanity determines if a person is capable of being held responsible for a crime committed by him, Insanity varies from one state to another, and in quite 44 few states in the USA, insanity defense itself does not exist. As mentioned elsewhere, insanity defense depends on the assumption that the defendant was not of sound mind when he/she committed the offense, and hence was incapable of appreciating the true nature of the crime. In certain cases, even if a person is found to be capable of standing trial, can still be declared not guilty due to insanity reason, or the trial itself does not take place. There are many definitions of insanity, viz., legal, moral and subjective. The legal definition of insanity says that the defendant is not responsible for the crime because he/she suffered from a mental disorder or some mental defect that made him/her incapable of thinking rationally or understanding of what he/she does is a crime, or that his action will have damaging consequence to the victim. The moral definition of insanity, however, states that the person lacks criminal responsibility because of a mental disorder or defect, and hence lacks the ability to understand and also appreciate his own misconduct as being a violation of the ethical behavior expected of persons in the society. The subjective definition states that the accused lacks criminal responsibility by virtue of suffering from a mental disorder or a mental defect which makes him/her believe that what he/she does or the crime that he/she commits is justified, even though the person is quite aware that his actions are illegal and is a violation of social and moral norms and standards. The tools used to determine insanity include mental screening evaluation by Slobodin and criminal responsibility assessment scales by Rogers. Assessment process is complicated, and forensic psychologists evaluate information from many sources and conduct diagnostic tests and interviews, and then provide the courts with their reports and insanity evaluation as their professional opinion. It must be remembered that insanity term is a legal concept and not a psychiatric one, and hence the psychologist's report or the psychiatrist's diagnosis being that the person suffers from a mental disorder, has no relevance to the court, and the latter does not accept it as an automatic proof of insanity. It is the job of the forensic psychologist to determine whether the disorder caused the defendant to lack responsibility and appreciation of the crime he/she had committed. For this, the forensic psychologists utilize a number of instruments to determine competency to stand trial, using screening tools and many detailed guides to conduct the evaluations. To give an example, the evaluation of competency to stand trial revised is a relatively more recent test developed mainly to address the defendant's factual and rational understanding of the legal proceedings and the defendant's ability to consult his lawyer. In addition to all these instruments, tools etc., they also conduct elaborate interviews focusing on symptoms, relationship between the symptoms and mental capabilities, and if they find that the defendant is incompetent to proceed, referring him/her for further treatment, etc. 11.6 Let us sum up. The present unit discussed the application of forensic psychology in civil and criminal proceedings. In this unit, we firstly discussed about forensic psychology and law. Forensic psychology, as mentioned in earlier units, is the application of psychology, its principles, philosophy and techniques to the legal/justice system. While law deals exclusively with legal issues, crime-related problems, the perpetrators of crime, their victims and the whole lot of legal issues. In the unit, we further discussed about forensic psychologist as an expert witness and forensic psychology in civil and criminal law. Civil law is concerned with civil or private rights and legal remedies rather than the public concern of crime, and criminal law is framed to impose punishment for the undesirable conduct with an intention to rehabilitate offenders to protect the society. Forensic psychology and assessment of civil and criminal competency was also discussed in the unit with a focus on assessment and evaluation competency to stand trial. Lastly, The unit also explained criminal responsibility and insanity defense. Insanity is defined legally as a defendant lacking criminal responsibility as he/she suffers from a mental disorder or a mental defect, due to which he/she is unable to appreciate the crime he/she has committed. And forensic psychologists can play an important role in this context.